I'm District Attorney Dan Dow from San Luis Obispo County, California, with an important message concerning the safety of our community. In 2016, voters in California passed Proposition 57. We were told it would allow early parole for nonviolent offenders, and only nonviolent offenders. Unfortunately, I and my colleagues, other DAs, and law enforcement around the state of California cautioned voters and told you that it would not only apply to nonviolent offenders. And as we predicted, in reality, other offenders who are convicted of violent offenses, such as the murder of a child, sex crimes, are eligible for these extra credits that the law gave the Department of Corrections and Rehabilitation the authority to give to inmates serving life sentences. So unfortunately, on Tuesday of this week, April 22nd, 2025, an inmate who's currently named Allie Hazel Brown, who at the time of the offense committed in 2012 was known as Herbert David Brown III of Paso Robles, California. Herbert David Brown III murdered his 22-month precious daughter named Lily. Lily died in February of 2013, and Mr. Brown at the time was convicted by his own plea to second-degree murder of Lily. That gave him a minimum sentence of 15 years to life in state prison. At the time, the law said that if you're serving a 15 to life or a 25 to life term, you have to serve every day of the 15 years or of the 25 years before you get a shot at parole. Unfortunately, in 2016, Prop 57 changed the law, gave the Department of Corrections and Rehabilitation the ability to award these violent offenders extra credits toward their sentence, leading to early eligibility of parole. On April 22nd, inmate Brown was granted parole after only serving 12 years of the 15 years to life sentence that inmate Brown was sentenced to serve. This is a person who was addicted to drugs, who was on a meth binge, and due to the influence of methamphetamine on inmate Brown, he tragically caused the death of his precious daughter, Lily. Inmate Brown should not be released from prison before serving at a minimum the full 15 years that he was ordered to serve. And so if you care about issues like this and the other recent similar examples of the parole board letting violent offenders back into the community, I urge you to do what I did. Today I wrote a 5-page letter to Governor Gavin Newsom, urging him to use his authority under the California Constitution to reverse the parole board's decision to release inmate Brown. Because inmate Brown is not in a condition to be safely returned to our communities at this time, based on the analysis of my prosecution team, who has thoroughly reviewed the record, including recent violent conduct in prison by inmate Brown. I urge you to join me sending a message to the governor: reverse the parole decision to release Allie Brown from prison at this time. I urge you as well to pay attention to other cases that are coming before the Board of Parole Hearings and send similar letters if you have concerns about other inmates. The time is now to protect our community by ensuring accountability, ensuring truth in sentencing, so that those who are sentenced to serve 15 years to life serve the sentence that they've been given by a judge or by a jury if a jury is involved. Our community deserves better. Precious Lily deserves better. The time is now, Governor Newsom. Please help ensure that we have justice for Lily Brown.